However, I wish to point out the collaborative partnerships with the judiciary. I was involved in the very initial stages of conversations around case management for the High Court in particular. And it was through our technical expertise that we rolled out the High Court registry audit. And it was through our interventions that we came up with a simple tool, the daily court return template form, which has withstood the test of time. Even with advancement in technology, I think the judiciary is still using this key tool as a way of ensuring accountability for what is happening within the institution.
Thank you. I think I'm happy with that. The other details will come out as you answer specific questions from the commissioners.
Thank you, Madam.
From the technical area, you can maybe tell us why you think it is important for a judge to be independent.
Thank you, Madam Chief Justice. I think independent is one of the most critical values that comes with any judge. And if there is no independence, then it undermines the entire rule of law doctrine, because parties will not bring their disputes for adjudication before a forum in which they do not have confidence in. The independence on the judiciary is anchored in the Constitution itself, and it's a delegated power from the people. Madam Chief Justice, I would say this as a judge. I think independence, the independence of the judge is a critical element to the public, and I think when that is lacking, then the public confidence wins. And historically, we know what happened in 2007. It was all about the suspicion on lack of independence within the judicial system that led us to the troubles we had.
Yes, that's also a big debate, because it's only one political case that was not brought to court. People still kept coming to court on other issues. But tell us, how would you secure your own independence as a judge if you are successful in this interview?
Thank you, Madam Chief Justice. If you look at my resume, you would see that I've been extremely transparent in what I do. I'm always transparent for my actions. In fact, in all the places I've worked, I operate on an open door principle. So for my administrative acts, I'll be very transparent to my colleagues. But one critical issue that I think we need to address is corruption, and the perceptions of corruption which undermine the independence. As a judge, from day one, in any station or in any leadership position that I will get, I will want the issue of corruption to be center in our conversations with my teams. I would want this conversation to be center when I do convene pre-trial hearings for any matter, so that when the parties come, it is very clear to everybody that that court does not have any corruption. There are no brokers. If we consistently repeat this and we draw the line, then everybody will oblige. There will be no suspicion, because so long as you indicate to the parties well in advance, then nobody will claim that he can reach the judge through other means, or he can reach any other court official on any other matter. So we will try to do this to reassure parties of the independence of the judiciary, and we'll continue this kind of messaging at all levels, even when we are collaborating with stakeholders and members of the public.
Yes, I'm happy with that. The next set of questions will be asked by the Honorable Mr. Justice Ibrahim.
Thank you very much, Honorable CJ and Chair. Council, I have a few questions for you, but some of the questions I had intended to ask you have been set out, you have answered, or rather in a way, by your CV, detailed CV. They have been answered there, and this is part of the interview. So I may not go into some questions that I had prepared. Now, your whole life you have been counsel and working in the NGO sector on human rights from the time you were at the university for your LLB and your master's, and subsequently working at the German NGO, GIZ. Yeah, they're called now GTI.
GIZ Kenya.
G?
GIZ Kenya,
Yeah.
my lord.
Okay. That time it was GT. Yeah. So, yes. So I've read that. So, now, I'll start with the issue of your work on and your litigation on human rights from the time of the medical legal unit that you are representing, and later on in your own practice, and also even in ICJ. You really have an experience. I could say you're an expert in matters which deal with counter-terrorism. And I've looked at your writings about counter-terrorism, and which you have dealt with in your various papers you have presented. Before the legislation in Kenya, you said that at the beginning in Kenya, before 2003, there was lack of clear, effective counter-terrorism law and its impact on foreign policy, while arguing that the continued backdoor, quote-unquote, implementation of counter-terrorism action, an effective piece of counter-terrorism legislation, acts as a catalyst for impunity and violations of human rights. So you started your work before even the legislation was there. What challenges were there before the legislation came? Was there impunity because of lack of legislation?
Thank you, my lord. I started working on counterterrorism because it's interrelated to torture. So if you look at the years, you'll realize I was still working on the topic of torture. And torture usually comes with other related challenges around the administration of justice. So what was happening at this particular juncture, we had persons suspected of terrorism that would be arrested, held incommunicado for long durations. They would be presented before magistrates on ex parte applications without representation of these accused persons. Judicial orders for further extension of detention would be made. So the system was not as tight as today. Today that cannot happen. And because there was no framework, then the problem was that the accused persons were being subjected to all manner of shenanigans in the name of law enforcement. We also witnessed a large number of Kenyans being renditioned out of the country to Somalia, to Ethiopia, to Uganda. And these were issues that were equally even discussed in Parliament, and the Minister for Justice then, who was Mutula Kilonzo, did concur that whatever was happening was not aligned to our laws.
Thank you. When the law was passed, the legislation was passed, this one called Separation of Terrorism Bill, which became law later. So what was the lacuna, or what were the inefficiencies, or even wrong provisions that still curtailed human rights regarding the issue of suppression of terrorism?
My lord, maybe you can repeat your question
the
again.
issue, for instance, the issue of burden of proof. Yeah, once a threshold was made by the police or counter-terrorism police of the accused person or a person arrested, the burden of proof shifted to them to prove that they are innocent. Like even wearing the hijab. Yes.
If you look at my paper, you would see that some of the issues around counterterrorism measures, the profiling in itself. that profiling has not changed. It is significantly much more possible for a person of Islamic background or religion to be arrested on suspicion of terrorism than a Christian. And those biases, those are the biases that still continue. I would not say they are not there. And the burden of proof shifting, I would not think that the burden of proof was on the accused person prior to the law being enacted. I would say that my argument then was that in the absence of a legal framework, then it becomes problematic even for courts, because these people are being arrested and being detained, but the framework that exists does not resonate with the purpose in which the security apparatus are engaging.
Thank you. Now, coming back to, you want to be judge of the High Court, and you must be aware that since 2010, the judiciary has always had visions, whether under the first Chief Justice after 2010, second Chief Justice, and now under our Honorable CJ now, she set out a vision which says as follows. The vision is judiciary's social transformation through access to justice, STAJ. What does that vision entail?
Thank you, Judge. I've had the opportunity of going through the STAJ blueprint. I would thank Madam Chief Justice for your initiative. In fact, it is the blueprint that caused me to make this application. The first issue I saw that is critical is the centrality of the people. The centrality of the people, and trying to introduce people within this blueprint and focusing on them, ensuring they access justice, is a novel approach, because what we witness in this country is that majority of the people do not have that opportunity. And when we deliberately go out as a judiciary to reach out to them, the judiciary will be performing the first cardinal obligation in the Constitution, which is ensuring that the Constitution itself remains a transformational document. And the social justice aspect of it seeks to assure that and guarantee. I looked at the pyramid and I saw where the people are located, and the two other strategies that were deployed by the two other Chief Justices Emeritus, and I felt that the centrality of the people, the shared leadership, the appreciation that for the judiciary to advance the transformational journey and to lead it, then the leadership must be in sync at all levels, not just at the top, but at the lowest level possible. And if that cannot be achieved, and it is all about changing the people's minds, because social transformation is changing human behavior, and the judiciary has taken the lead, and I thought this is the opportune moment to support that in whatever ways we can.
Thank you very much, Counsel. I wish you all the best.
Thank you, sir.
Thank you, Judge. Commissioner Macharia.
Okay, Bwana Mohoshi, I know you for a long time, worked very closely with you in human rights issues when I was in IPOA. I know you from ICJ, and I can confirm all you are saying. Now, there's no doubt about the issues of your integrity, your human rights, involvement, and your understanding of the law around it and all that. Now, what I would want you to convince the Commission is that you will also be judge ready in regard to other aspects of the law. Because as High Court judge, you could be posted to Commercial Division, you could be posted to Family Division, you could be posted anywhere, except, of course, the other specialized courts. Would you demonstrate to the Commission that regardless of where you are posted by the Chief Justice, you'll be able to run the course? I know your concerns previously has been about delays in courts. I've had you, submitting extensively on that in other forums, and the issues of accountability, which I know you are good at, so that I'm not concerned about that. It's about now the other branches of the law, if you are indeed taken to those areas to go and adjudicate.
Thank you, sir. Maybe I can just say that as a leader and as a manager, I appreciate in operating within policies and procedures. The reason I say this is that the small gains we make is what takes us to where we are going. And all the gains and all the minimal gains we have made as a judiciary are things I have to take into consideration as a judge. The framework of which a judge is supposed to operate is already provided. So we have Order 11, which is, it's a novel instrument of running the court. It provides timelines. I know the challenges that exist around that Order 11. As a judge, as I had mentioned earlier on, I would be judge ready. I would, from day one, I would want to analyze what is my docket. So as soon as I'm allocated a docket, I would want to scrutinize it, to understand what this docket is all about, the nature of the cases. I will want to segregate them, so that then I can develop a proper strategy of dealing with the different categories of cases. However, as a judge, I think the role of the judge has slightly changed from what it was before. We also have a duty to ensure that these matters are proceeding. So I would take deliberate measures. And the first one is to have conversations with the parties. If all the parties can come to court on the first mention, even if it is a pre-trial, the conversation we'll have there, we would assess the resources required, we would assess the time required, and this is the opportunity for the court to demarcate its lines on how this matter will proceed. And I think no party will come to court and say, I am in no hurry to have my matter concluded. Even though we know that there are matters that come to court and these parties do not have the intention of concluding their matters. So I would want to do it very early, and as we move, for example, we have Order 11 and the 30-day window when the matter is filed and the pre-trial starts. That is a window that has not been tightened up. And I know once the judiciary does that, then it will hasten the way the matters are moving. You'll not have matters at pre-trial for 6 months.
Okay.
Yeah.
So what, if I'm getting you right, that if you are sworn in, you are a judge, our colleagues again will not start saying that, Judge Mohochi became now a judge, and he's just, he can't just move a matter and deliver a quality decision on, say, a commercial matter or family, and all that.
The diversity of the jurisdiction of the High Court, I appreciate it fully. And if you look at the areas of work I've been involved in, you would realize that these areas are critical to the jurisdiction of the court. I've been involved in administrative law as a litigator. I've been involved in constitutional law litigation. I've been involved in criminal law litigation. I've been involved in corporate matters, insolvencies.
All right.
So that diversity in itself is a plus. However, the fact that I've worked in multiple institutions, working with diverse teams, that is also indicative that my move from wherever I am into the judiciary will not be the first time I'm moving to another institution. So I can fit in pretty quickly. I'm a fast learner, and I do believe that we do not have the benefit of dragging our feet. So from day one as a judge, in my mind, I should be able to perform all the duties that come with the office of the judge.
Okay, thank you. I wish you well.
Thank you very much. Judge Wasame.
Thank you very much, Wakili. 2 questions for you. Is the death penalty unconstitutional?
My lord, death penalty,
And you start yes by no first.
my lord, it is a no. It is you see, under the right to life, there is a derogation which
I'm
is
just asking
provided.
very straight question. Listen to me, please. Is death penalty unconstitutional in our legislation?
Death penalty is not unconstitutional.
It's not unconstitutional.
Yes.
What is your view on death penalty?
My view on death penalty is that it should be abolished.
And as a judge, are you a judge who will derogate from section 296(2) of the Penal Code, 203 of the 203 as read together with 204, and the one dealing with treason?
As a judge, I cannot do that. I am bound by the law and the Constitution. So unless the policymakers, and this was an issue in Bomas, so unless it is changed from there, I will operate within the legal framework that exists.
Okay. I wish you well, Your Honor.
Thank you.
Thank you
Order
very
of
much.
procedure.
Commissioner Majanja.
Thank you, Chair, and good morning.
Morning, sir.
I can confirm that Mr. Mhochi has appeared in the commercial division several times. He's not a new person there. Now, the Companies Act 2015 heralded a new company law regime. In what ways has it protected the rights of minority shareholders? Can you give us 2 ways in which it has protected the rights of minority shareholders?
Thank you, Judge. I think that particular piece of legislation introduced the derivative action provision. It lowered the threshold, thereby enabling minority shareholders move the court on issues of their concern. The other aspect of protection of minority shareholders, I think it strengthened the obligations and responsibilities that come with directorship. It introduced criminal liabilities on company directors that do not abide by the law.
Okay. There's also an action for oppressive conduct. Maybe you can catch up on that. Giela versus Casman Brown. I'm sure you know the principles, and since I'm sure you've been listening to the interviews, you've gone to understand the case. Eh?
Yes.
There are more recent Court of Appeal decisions elaborating the principles in Giela versus Casman Brown. First and foremost, does any recent Court of Appeal decision come to mind on application of the conditions in Giela?
I'll have to check that.
Okay. Have you ever heard of a case called Guruman Limited versus Jen
I think it's a Supreme Court.
Nielsen?
Yes. I think I know the facts, but I don't know the outcome. I think it was in the Supreme Court.
Let me now ask you in another way. Yeah? If you find that there is no prima facie case without prima facie case, can you grant an injunction on the balance of convenience?
No,
Why not?
because the first 2 tests must be exhausted before you can get to the balance of convenience.
I thought it says if you are in doubt, then you apply balance of convenience.
You see, if there is no prima facie case, for example, with probability of success, then the injunction you grant becomes academic.
Okay.
Yes.
Okay. Fine. Finally, you are seated in, say, Kisumu, and you are confirming grants. As part of that exercise, an old woman comes before you with a gentleman, a very young gentleman, standing next to her. And she says when my husband died, this man supported me by financing the funeral because I had to buy 10 cows, slaughter. So in exchange, I'm giving him half of my land. And on the application for grant, it says, Mr. So-and-so, half of this land. Would you proceed to confirm the grant
No.
on that basis?
No.
And if so, why? If not, why?
Thank you, Commissioner. I think for starters, that individual is a stranger. That individual is not a beneficiary. And if then there was any room for confirmation, you would rather confirm it to the beneficiary directly than seek to introduce strangers at this juncture. Maybe I can also mention that if you look at this issue of succession, you would find that maybe the only room that is permissible to undertake such an exercise is if there was a transaction by the deceased person, a transaction that had not been completed. Then under those circumstances, the court can intervene to redirect that property to where it's supposed to go. Otherwise, these consequent agreements by beneficiaries cannot be subject to the succession.
Okay.
They can only do it outside.
Thank you very much, and wish you well.
Thank you.
Yes, thank you very much, Commissioner Nguti.
Thank you, Chair. Good morning once again, Senior. I've also known you for many years since my admission in, with regards to the work that you have done in the human rights arena. Judicial overreach is a threat to separation of powers. Do you agree with that statement? If yes, if no, why?
Thank you, Commissioner. I do agree with that statement.
Maybe give explanation.
And I'll speak about this from the context of the High Court. I think the High Court has a very broad jurisdiction, which includes the equitable reliefs, which includes reliefs that would alter implementation of state programs. And these equitable reliefs are granted pursuant to discretion. And I think that is where the problem usually arises, because when a judge is exercising discretion, that judge has to take into consideration all factors, including the factors around him and the consequences of that decision. And in instances where discretion has not been exercised properly, then there runs a risk of that decision exceeding and going into the realm of policy formulation and policy direction. So to that extent, it is a possibility, and it is something that judicial officers must constantly be alive to, especially when they are exercising their discretion.
My second question is with regards to couples in a cohabiting relationship. Do they require any form of protection, and if yes, what protection?
I think the Marriage Act today recognizes come we stay. And these are couples who have decided to live without officiating their marriage. I will, however, say that same-sex couples would not get protection of the law at the moment in this country, because that is prohibited.
The Marriage Act actually does not recognize cohabitation. So if parties come to you in that type of a relationship, what protection do you think the court can grant them? And I'll give an example with regards to quote-unquote property, matrimonial property. Let me use the word property acquired during their union. Can they get any redress?
We have the concept of presumption of marriage. This concept precedes even the legislative crafting referred to in the Marriage Act. And I think to that extent then, if the presumption of marriage can be demonstrated, then protection should be availed by the court to the parties moving the court.
Thank you. My last question is on decisional independence. Do you think incompetence affects decisional independence of a judge or a judicial officer?
Yes, I do.
And would it be a proper ground for removal of a judge or a judicial officer based on incompetence?
Yes. If the incompetence is such that it is dragging everybody behind, then I think the Judicial Service Commission can take action and make it a substantial ground for removal.
Okay.
Yes.
Thank you so much, Senior, and wishing you the very best. Thank you, Chairperson.
Thank you very much, Commissioner Gishoi.
Thank you, Madam Chair. Just one or two issues that maybe my good friend can elaborate a little bit. In your opening remarks, which I listened very, very carefully, you talked about something period 2010, and I'll not call it, but for lack of a better word, compliant judicial officers, in the sense that they handle cases. If that were to happen to you as a judge, that I'm using that compliant, at commas, what would you do? Compliant in the sense that you see in the opening remarks that some judicial officers, one or two, did that way. What would happen to you as a judge if that were to happen? Would you proceed?
Thank you, sir. I think complacency is something that occurs in a workplace, and for starters, as a leader, when you start seeing such kind of things, you have to engage in some introspection to see what you can do about it and what level this is. As a leader or as a judge, for starters, I will try to inspire my teams, so that when you find that there's some level of complacency, I'll try to convene, for example, whatever structures exist. If it's a leadership management committee, we'll have that meeting. We'll lay everything on the table.
Okay.
The earlier we do this, the better, so that it is fully understandable to everybody, the concerns. Because I would rather not have any concerns against me from my immediate team before any concern reaches the JSC as a judge.
Okay. I asked this question because you said, and I've read your CFE very deeply in human rights, and you talked about those early years. There was a judge in a court here in Kenya, Leo, and that judge, a matter was presented to him, and the judge actually declined and he resigned. A big matter that was dealing with human rights. He might not have been a Kenyan citizen, but he left. What would you say about it? Would you, if that situation happens to you, what would you do as a judge?
Okay, for starters, I would say I would be hesitant to rush to tender resignation just because of a single matter.
Mm-hmm.
And the circumstances of that case were different. This person was on contract. We don't know what was happening around his life.
Okay.
I think being a state office and the responsibilities that come with this office, I would say that we should be able to overcome challenges that come our way without undermining the primary purpose. So as a judge, I would not be quick to tender resignation just because of a single case.
What would you do? That's my question. What would be a reaction? Would you proceed, or would you escalate that matter to the Chief Justice? What would you do? And I'm asking that question because I know you know about that matter.
This is a scenario where there is intimidation, for example. Intimidation against the judicial officer by extraneous factors, people who are outside. First and foremost, we must constantly be alive to the work we undertake and the seriousness of the work we do, and the threats that come with it, because you have to always assess the threats that come with this. And if you think there are any individuals who are complacent or frustrating the due process of the law, you will look at what are the powers, the immediate powers of the court. What can the court do about this? If it is an issue to be escalated, for sure it will be escalated.
Okay.
It will be escalated within the procedures provided for.
Okay.
Yes.
Now, to come to my area, just one question. You want to go to the High Court. You'll be a state officer, I believe, and I've seen you have done some work for some counties here, even in your capacity. And Article 232, there are a number of key values and principles that guide all state officers. I just want you to pick 3 of them and demonstrate to this commission how you are going to promote or enhance those values as a judge, the High Court, at individual level, and also at a corporate level, corporate institutional level. Please.
Thank you, Commissioner. I'll start with your last question, and I'll give an illustration. As a leader, I was accountable to my board. When I went to the last tour of duty, ICJ Kenya, I found they had an appraisal system. The culture was that nobody wanted to be appraised. So I looked at what exists. I reassured the team we will have to change it, and we came up with a new, which was approved. However, when it was my time to be appraised, I went out of the way and said, kindly do a 360. So I was subjected to a 360 audit from year 1 in ICJ.
What was the result?
Positive.
Good. Next one.
The next one is accountability for my actions.
Accountability for your actions. Your judgments and your rulings.
All actions, including administrative actions. First and foremost, as a leader, I operated on an open door policy. I was accessible to everybody, so that whenever I made my decisions, these were not decisions that were just being made without consultation. So
Okay, the last one, so because of time.
the last one is prudent use of state resources.
Good.
And here I would say that in my 17-year leadership career, I've been entrusted with close to $7.2 million.
$7.2 million.
Yes, they have been audited annually, religiously, and I have not had a single qualified audited account.
Very
for
good.
the 17
Just
years.
to wind up now on that particular part of use of resources, there are 2 key legal instruments or statutes that guide the use of public resources. Would you share with us those 2?
Yes. I think there's a Public Finance Management Act
Good.
and the public disposal of public assets, the Public Asset Disposal Act.
What do you call it? What, you are the lawyer.
I'm just mixing up the name, but I can get the name within a minute.
Okay.
I have it.
Thank you.
Yes,
Thank you,
thank you.
Counsel. Thank you, Chair.
Thank you very much, Professor Mugenda. Thank you, Honorable CJ. I have 2 questions for you, Counsel. And the first one, in your application, you've talked of innovation and being innovative and resource-oriented. So my question is, could you give us instances where you can get the credit for some innovation that you did?
Thank you, Prof. I think I'll pick one which I'll regard as the most impactful. In the course of working on the counter-terrorism issues, I became victim myself, so I was prevented from entering Uganda. I was not the only one. I immediately looked at what has been happening to me. While I was still in Uganda, my head was very clear that this is an issue I will challenge. I tried to reach out to the rest of the people I was with. They did not join me. When eventually I moved to the East African Court of Justice, the precedent that came out of that court, in my estimation, has further opened up the movement of persons within the region. It has further promoted the principles of the treaty, and I think it is a decision that further entrenches the culture of accountability and human rights. I say accountability because there were two issues in that decision that the court dealt with. The limits of sovereignty, whether a state can invoke sovereignty for a person who has just arrived at the airport without notice. And I think Uganda was faulted for this, and the limits of sovereignty were curtailed, and they cannot overlap to run counter to the provisions of the treaty and the charter.
So what was your specific role in all that?
This case is a case bearing my name, and I was involved in this case intricately from when the transgressions occurred on me to the point where we filed the case and had it argued in court.
Okay. My second question is, you talked very emotionally about the two instances which shaped your career, the case of divorce and the case of your dad. So, as a judge, do you think such emotions can affect your judgment? How are you going to moderate your emotions as you make your judgments?
Thank you, Commissioner. And maybe the entire commission, when you look at my resume, you'll see that I've interacted with a lot of what you term a lot of adverse emotions. I've dealt with death very closely. I've dealt with victims and survivors of torture that are extremely traumatized, people who have lifelong effects on them. This has been my constituency. And for one to participate in offering services in such an environment, one has to be very, very careful, because you'll end up getting secondary traumatic, post-traumatic stress. It is something that can affect you as a person. So one must really be able to manage your own emotions, to distinguish your emotions when you're engaging in your work, to offer empathy to these people that you're serving, and to be able to offer your work without emotion, to detach emotion from what you're doing. That is what has kept me going, and I think it is more or less the same thing the judges undergo on a day-to-day basis.
And lastly, Counsel, in your 2010 consultancy, you wrote something on pornography of poverty. What is that? Just briefly.
Thank you, Commissioner. It was a keynote speech I made in Dublin. It was not a consultancy.
Oh.
And the theme of the conference was use of images. It is all about how the West portrays this part of the world, where they would have a big billboard with a small baby with flies all over his eyes and mouth, and they will write there that with just £5, this kid is assured his life for a month. So that is what I meant.
By the is it a word that you
Yes,
coined,
yes,
or
it
it is
is-
there in the literature?
No, I did not coin it.
Is it there in the literature?
Yes,
Oh,
yes.
okay. Thank you, CJ.
Yeah, thank you very much, Commissioner Rwanda.
Thank you, CJ. Good morning once again.
Morning, madam.
Yes. Earlier on, you referred to an incident where your performance was being appraised and you requested for a 360 review. And I've heard you speak about case management, I've heard you speak about performance, so I believe you must be aware about the parameters that we measure in the judiciary. So I just wanted to get your opinion on whether you think the scope really covers 360 degrees of what a judge does.
Madam Chair, Chief Justice, I think part of my work has involved myself even in the performance management of the judiciary. So in 2018, that is maybe not even in my CV, in 2018, I was approached by GIZ, which is a partner to the judiciary, and they commissioned a consultancy. This consultancy was undertaken by ICJ Kenya, and the lead consultant was Winfred Nderitu, senior counsel. And the purpose of that exercise was to evaluate the judiciary performance measurement, and also to design a tool I know we attempted to reach out to the judges. We had difficulties. The responses were limited, but we did a report. And in that report, we attached a tool. Some of the things that we were proposing there was that the system needs to be enriched so that over-reliance on the mathematics, that should not be the only option. There are other issues that can be measured. And that is why I used the personal example of mine. The things that were contained there were things that people can observe, colleagues can talk about. We should all be comfortable to be judged by our colleagues. So if we can have a hybrid system where there are other elements that can be measured, then in addition to that, we also proposed the weighting, case weighting. If case weighting can be introduced, then the work being undertaken by the judicial officer, because you know, like we have magistrates in the anti-corruption court where I practice, the volume of work they are dealing with, one case can be equivalent to 10 cases. The sheer volume of work being undertaken on that one case. So if case weighting can also be introduced, then the system will be much more better than it is. Yes.
Okay, so your proposal is that maybe we should incorporate feedback from stakeholders in our assessment.
And the teams. So that assessment should actually be undertaken at the station level. Yeah, so that you also inspire confidence to the people you lead.
Okay.
Yes.
You don't foresee any challenges in that?
It will be gradual. This is something that can be introduced gradually, so long as it is done objectively. Yeah. Maybe in the initial periods, people will be throwing around rumors, but after that, it is a system that enriches the institution in terms of just pulling together, because we need all to pull together. Yeah.
Okay, thank you. I don't have any more questions to ask of you. I have looked at your application. It's complete, save that it doesn't appear you filed your financial statements for the law firm.
I did. In my original file, actually they're even online. Everything is online.
The information I have here is that you did not file that. But the rest of the documents are okay, and in terms of the background information we have on you, you are recommended as a human rights practitioner, and yeah, I thank you for that. Thank you, CJ.
Thank you very much, Council, for that very engaging interaction with the Commission this morning. I wish you all the best. This brings us to the end of the interview, but we'll give you an opportunity to ask us anything.
Thank you, Madam Chief Justice. I have just one question, and this touches on the concept of researchers. The Judiciary has rolled out provision of researchers to judicial officers. I would wish to know whether there is a performance measurement system for these researchers, and whether the same has been aligned to the Judiciary performance management system. I know the researchers are on contract. Thank you.
Yes. Yes, we do have legal researchers. As you know, they are provided for under the Judicial Service Act, that a judge is entitled to a legal researcher to help the judge in research work. Everybody in the judiciary gets evaluated, and everybody signs a performance contract, agreeing on, you know, what are the deliverables. So, but the performance of the legal researcher depends on the inspiration by the judge, because, you know, there are judges who are even reluctant to use the researchers. So if they are not giving the volume of work to the researcher, of course the researcher will be limited. And since this is also a new career we have introduced in the judiciary, it is some work in the progress But yes, everybody gets evaluated. Yes. Any other question? Okay, thank you very much. We wish you well. We'll be in touch with you when we complete the process.
My name is Patrick Wishavi.
Thank you, Commissioner.
David Mazaja, Commissioner, welcome.
Thank you, Commissioner.
You're welcome.
Thank you, Commissioner.
Good morning, Senior Jacqueline Ngucha, Commissioner. You're welcome.
Thank you, Commissioner.
My name is Olive Mulinda. Welcome.
Thank you, Commissioner.
Good afternoon, Council.
Good afternoon, Commissioner.
Mohamed Warsame, karibu.
Thank you.
Mohammed Ibrahim, Commissioner, karibu sana.
Thank you, Commissioner.
Yes, thank you very much, honored commissioners, for that introduction. Council Monari will start the interview. Make yourself comfortable. In the event that you want to seek clarification, when you are asked a question, this group is going to have a very engaging interaction with you. You can start by telling us your county and your ethnicity.
Thank you, Chair and Honorable Commissioners. My name is Josephine Waliwa Wambua Mongare. I was born and brought up in Makueni County, but I'm married in Nyamira County. So my ID shows my county of birth as Makueni, my residence as Nyamira County.
Which one do you identify with?
I identify with both, Chair.
We have to choose one, which you feel you have a stronger affinity.
I've been married in Nyamira for 25 years.
So that is enough.
Yes.
It's longer than you live in Makueni.
Actually, it's almost equal time.
Okay, but you can indicate here in Nyamira.
Yes.
I believe that there are some question to ask you about that. And your ethnicity is Kamba.
Yes, I'm Mkamba by tribe.
Very well. You know why we asked? those
Yes,
questions?
yes, I'm aware, Chair.
Yes. So now you can briefly tell this commission why you applied for this position, what you are looking for, especially what values are you going to bring to the position of a judge, why you think you are the best person to be picked for this position, and in particular, if you could highlight some of the key achievements that you have attained that relates to this.
Thank you, Chair and Honorable Commissioners. I am an advocate of the High Court of Kenya. I was admitted to the bar in 1991, and therefore I practiced law continuously for 30 years. I hold a master's degree in law in cyber security and data privacy from the University of Loyola Marymount, University, California, United States. I also hold an LLB from the University of Nairobi, and of course a diploma from the Kenya School of Law. I'm trained in mediation and arbitration from the Chartered Institute of Arbitrators Kenya, and I've also trained in corporate governance and leadership. Since I became a lawyer in 1991, I have actively practiced as such in the various courts of Kenya, right from the magistrates' courts to the highest court of the land. And I believe the cumulative experience of 30 years makes me suitable to offer my candidacy for the job at hand, which is the High Court judge. Chairperson and commissioners, in 1994, I set up the firm of J.W. Wambua and Company Advocates. And since 1994, with the exception of 2.5 years when I served at the Kenya Anti-Corruption Commission, I have been in active legal practice. I practice in the civil courts, in the criminal courts, and in all divisions of this of the High Court. I've also practiced in the court martials, defended a few cases in the court martials, and even in the Admiralty Court in Mombasa. So cumulatively, I have earned skills that I think are useful for the position that I've applied for, which is the High Court. I have good drafting skills, writing skills. I communicate clearly and effectively. I write my own pleadings, my submissions, and I make presentations before all the courts if and when I have a matter. And I think in most of the matters that I have defended before the High Court and in the lower courts, I'm always more than not successful. This is because I prepare very well for my cases. I do research, I look up the relevant law, and I look up all the statutes that will help me in presenting my client's case. Alongside the practice of law, Chairperson and Honorable Commissioners, I served in various institutions in this country. At the onset of my practice, I was invited to join the board of Nairobi Water Company at inception in 2003, and I served there for 4 years, where I helped set up the company from a department of Nairobi City Water, Nairobi City Council Water Department, to a public company. I helped in, because I was chair of the Legal Affairs and Human Resource Committee, I helped set the departmental standards and create the public entity that it ended up becoming. This I did through, of course, negotiations with the councillors of the time to show them why it was necessary to delink and make this company independent and functional. Alongside my practice chairperson, I have also served at the CPD, the Committee on Continuous Legal Education, currently called the CCPD Committee of the Law Society. I served there for 10 years as a committee member, and I was instrumental in developing the current curriculum that is used to train members of the Law Society in the emerging trends of the law. At the CCPD committee, I gained insight and good skills in managing people, managing diverse group of people, and even being able to sell ideas why some changes had to happen. I recall at my time at the CCPD committee, it was at the introduction of the court annexed mediation, and the membership of the Law Society was not up to it. They thought that court annexed mediation was going to take away valuable legal work from them. And so we did a negotiation, and we brought in Judiciary and had sessions where eventually we sold the idea to the membership, and now it's been accepted. I also served at the Public Procurement and Appeals Review Tribunal. At the Public Procurement, I had legal disputes around public procurement and disposal of public assets. Here I gained valuable skills that I believe, if I am successful, will help me in the office of the High Court Judge, because I learned how to write judgments, well-reasoned, well-researched, and supported by case law. I also learned to listen, to be able to exercise my responsibility as an arbiter fairly and based on the facts and the law, and also was able to know how to remove my own personal biases from any cases that appeared before me. I served for 6 years, from 2013 to 2019. Honorable Chair, alongside that, I also served in the Council of FIDA, Kenya. At the inception, when I joined the board, I represented the council at the Technical Committee for the National Council of Administration of Justice. And during that time, we went around the court system and the police stations and all the institutions that are represented and saw firsthand the changes that needed to be done. I was part of the team that drafted the original NCAJ strategic plan. I then moved, when I became chair, to the summit, and I chaired the Sexual Offences Act committee that was tasked in revising the policy and proposing amendments to the law on the sexual offences. I'm pleased to note, Honorable Chair, that some of the changes that were envisioned were actually captured in the Children's Act, and also jurisprudence that is emerging from our courts takes cognizance of the challenges that judicial officers and judges were experiencing in applying sentences in the Sexual Offences Act.
Yes, I think we are now getting into the technical area.
Yes. Maybe I just conclude with what I'm doing currently, Chair. Currently, I joined my husband in the US, where he's been posted to the Embassy of Kenya as a diplomat. And during that time, I got to go back to school, finish my master's, but also worked alongside continue to support my law firm here. I worked with a law firm in the United States. I did a little bit of immigration law, and then I am currently supporting a human resource company on a day-to-day basis, where I help them review contracts based on the compliance of the federal statutes, the American Constitution, and the state laws. Maybe I conclude by saying that other than just active legal practice, I've been a consultant in human rights and gender, and even in governance for various international NGOs, the UNODC, the UNICEF, both here and outside. And I did actively participate in the dissemination of the Comprehensive Peace Agreement for the South Sudan and the drafting of the Constitution.
Yes, indeed, you have a very, very wide scope, and those of us who have worked with you know your capacity, especially in building institutions. So we'll go into the technical area, especially because you will be interpreting the Constitution on a daily basis, and you can tell us, you know, as a judge, we are very, very keen on having judges who are independent. Tell us how you secure your own independence as a judge.
Honorable Chair, when I served at the Public Procurement Appeals Tribunal, I got in at the onset of the new administration in 2013, and I learned firsthand the vested interest in public procurement matters. And so I learned to be removed from the agenda that was not part of the case before me. I believe the skill sets that I gained in interpreting legal decisions at the public procurement, I can carry that forward and bring them to the High Court. I learned to apply the facts and the law, irrespective of the pressure that was either out there in the public or even directly from the government. I learned the value of being applying the law as it is and being independent. My lady, Honorable Chair, one of the cases that I handled was the Jubilee promise of laptops. But when we reviewed that case, and I was the chair of the board at the time, it was clear that even if that was the motto and the driving agenda of the then new government, it was going to be an error to allow that judgment to go through. And so we applied as a board the facts of the case, the evidence that was availed before us, and the requirements of the Public Procurement Act, and we set aside the tender because we found it flawed. Yeah. At that time, I actually felt pressure because it was an expectation of the general public from the government. I believe I am independent enough to be able to differentiate what is before me and what is out there, and not bring it to the courtroom.
Yes, another tool you employ is the Constitution. When they bring pressure, you tell them actually they are breaching, they are violating the Constitution.
Thank you, Chair.
They interfere with your independence.
Thank you, Chair.
Maybe you can also briefly tell us what are the powers given to a judge under Article 165 of the Constitution.
A High Court judge, Honorable Chair, as original and unlimited jurisdiction to interpret matters that are civil and criminal in nature. A High Court judge has powers to interpret the Constitution and any laws that may be in conflict with the Constitution. A High Court judge has supervisory powers over subordinate courts and tribunals and other quasi-judicial bodies that are subordinate below the High Court. An High Court judge has power to listen to sit in appeals, I think it's appeals or tribunals that are set up maybe by the JSC as a member of a tribunal to hear tribunals about a disciplinary case, about a constitutional member, except the president. A High Court judge has appellate jurisdiction to hear matters on appeal from the lower courts.
Thank you. I think you refresh on how the High Court can sit with the tribunals. Any exception, any jurisdiction that is not around the High Court?
Yes, the High Court does not have original jurisdiction in election matters, and neither the High Court, neither the land matters or labor dispute matters.
Election matters, we also refresh on that, particular jurisdiction.
I know the jurisdiction has to be gazetted and created. It's not original.
Thank you very much. The next set of questions will be asked by Justice.
Thank you, Chair.
Thank you, Honorable CJ and Chair. Council, I have a few questions.
Thank you, Chair.
I've read your CV, quite a wide experience and background. So some of the issues that I would have asked are already contained in your CV. I'll just go to the issue now. When the Honorable CJ took office over 1 year ago, she launched her vision for the judiciary, and it's called the Judiciary's Social Transformation through Access to Justice, or what we call STAJ. What do you think, what is your view of this, and what does it entail?
Commissioner, I believe the STAJ is a very big vision that brings in the Constitution into play by ensuring that access to justice cuts across such social barriers. And these social barriers could be gender, could be physical disabilities, could be age, either youth or elderly people, or other people disadvantaged in one way or the other. So the social transformation through access to justice envisions access to justice for everyone. And this is by probably, when I was thinking about STAJ yesterday as I prepared to come for this interview, I remembered my village in Ukambani, and I'm imagining if we reduce the distance, the physical distance is envisioned to less than 100 kilometers, there'll probably be a court in Katonzweli sub-county or Makueni. And that would be nice because people have to travel to Makueni headquarters for hearing of their cases. Other than that, the STAJ envisions use of other tools to enhance access to justice. And this is the application and the implementation of the AJS, the alternative the justice systems that are embedded in our customs and in our traditions that are recognized by the Constitution. And also the other ADR mechanisms of the court-annexed mediation, arbitration, to have quick disposal of cases all around and make sure that justice is not delayed, because justice delayed is justice denied.
Thank you very much. What made you, as I've seen that you, in your second degree, on Master of Laws degree,
yes,
in the US, you specialize in cyber security and data privacy. What compelled you, or what was the underlying reason why you took that course?
Honorable Commissioner, master's degree in America, because the JSD is a second degree, which is the Juris Doctor, is a second degree for lawyers, master's degree is almost open to foreign students. And so when you go to the university, because they assume that you want to pass the bar, the first degree you are offered is bar track, LLM. But then I asked myself, if I do a bar track and pass the California bar, and I come back to Kenya, what will I come back here with? So I looked at the available courses that were being offered, and I chose cyber security because it's an emerging area of practice, and it brings in the new trends in legal practice. First, almost every other crime will have a cyber element, and data privacy, because we are now a data-driven community. We are now using ICT, our money is out there in our phones. What are the limitations of those freedoms that ICT has come in to bring? And so the degree was, for me, I wanted to go to school and study an emerging area because I know the future is digital.
Thank you very much. You did state quite for some time at the procurement review board.
Yes.
And where you had cases as chair.
Yes, Commissioner.
There is this issue that if there is an appeal from the decision of the review board, it will go to the High Court, is it?
Yes.
And within a certain time, and the decision of the High Court is final.
Yes, Commissioner.
Yeah. What do you think of that finality clause? Is it appropriate, or do you think it is limiting to the access to justice, that parties cannot go to the Court of Appeal?
Commissioner, the reason why there are limitations in the public procurement law is because public procurement is a perishable commodity. Government institutions are supposed or expected by law to have a one-year cycle within which they have these budgets, they procure goods and services, and they are supposed to make sure that at the end of the budget cycle, they have absorbed the funds that were allocated per department. And so I think the drafters of the law saw that if there is a prolonged court process, then the year will run before those goods are procured, services are rendered, and therefore what then happens is that that product perishes. You are aware about the public finance management law that requires that if funds are not utilized within a budget cycle, they have to be surrendered back. What then that means is that the department that are budgeted to use that money, if they are tied up in court, then they do not get to spend that money, they don't get to render that service, and probably for the next budget cycle, they won't get that allocation again. There are two stages of appeal from there. Yes.
You have answered
Thank
the
you.
question.
Thank you.
Finally, did you do some online cases in Kenya when you were in the US during the last 2-3 years during the COVID period?
Actually, when I went to the university in 2020, I did the first semester as an in-person student. Then COVID happened and we were locked down. So my second semester was done online. I did Zoom classes. While there, because I'm still affiliated and attached to my law firm, I get to appear in court. Because of timelines, sometimes I'll appear very early in the morning, and because we are 10, 11 hours behind, because we're in the West Coast, and then sometimes I will delegate to the people in the office. So I do virtual hearings. Yes.
Thank you very much, Counsel, and all the best.
Thank you, Commissioner.
Okay. I think I'm one of the few who know you
Thank you,
for very
Commissioner.
many years.
Thank you, Commissioner.
And I have no doubt you are judged based on my personal knowledge and experience.
Thank you.
On my personal knowledge and experience.
Thank you.
dealings with you. So could you tell, of course you have to convene the rest of the commissioners. Now, could you tell this honorable commission 3 things you do differently if you became a judge in terms of ensuring that you have an accountable judiciary, you want that is expeditious, and also in terms of the quality of decisions that are churned out of the courts?
I will bring my long experience as a lawyer to the bench. And my experience has been that you have to have proper time management. One of the things that I had to do, because I served both at public procurement and at FIDA at the same time, was to plan my time in such a way that my 3 institutions that I was giving time were adequately presented. So I would do my very early morning meetings, 7 o'clock at FIDA, go to my law firm if I have cases, attend to them, and then we sat 3 days a week at the board in the afternoons. So I'm a very good time manager, or rather I segment my time in such that I have to do what I have to do. Another thing is that because we had a 21-day period within which from filing to judgment for the appeals that were filed before us, I found that I dedicated my evenings to writing any decisions. And remember, Commissioner, at the board we were 2 lawyers and 6 other non-lawyers. So most of the writing, if you're chairing, you ended up writing most of the decisions. And then if the non-lawyers wrote the decisions, you have to look at them just to make sure that they were in compliance with the law and the constitution. So I segmented my evenings for writing decisions. And therefore, I had to quickly learn how to type my proceedings, my decisions, and make sure that they are sound and that they actually communicate the decision. So I have good time management skills. I'm diligent in what I do. I like to give my best to anything that I do, whether it be a leadership position, whether it be a client I'm representing, whether it be somewhere where I'm volunteering my time. And so I bring diligence, commitment to the work that I do to the judiciary. And then I think I have what I would call integrity in the work I do. Yes. So I bring integrity to everything I do. I believe in being me. If I tell you that I'm going to meet you at 2, I will come. If I cannot, I'll give you adequate notice why I cannot show up. I keep my word. I believe in doing the right thing all the time.
Okay. Now my final question, hope you're aware that if you do become a judge, you have to now completely come back to Kenya.
I'm aware.
Because you want to become a judge.
I'm aware.
You always have the time in America. I wish you were.
Thank you. I know that, and we are also coming back because we only served for 4 years. So we're about to come back.
Why do you use the word we?
Oh, my family and I. My husband and the children and myself.
Okay.
Yes.
God willing, on your first day in office, you have 2 matters. The first one, challenging a decision by His Excellency the President on a state of emergency. And the second one is a judge who is challenging a decision of the tribunal that removed him from office. How will you rule?
If there is a state of emergency declared by the executive, it means that there is a public interest matter at hand. And though based...
Go directly to the point,
yes.
The decision.
And so I would rule in public interest, if it's a public interest matter. And then public interest is subject to interpretation. So depending on how I interpret the public interest matter to be, maybe it's not urgent, I may stay it. If it's urgent, I may allow whatever orders that are.
Second one?
I'm not very conversant with whether, as the chair has pointed out, that I will have jurisdiction to hear that matter. challenging the tribunal's decision.
Okay.
Yes.
In both cases, you don't have jurisdiction. That's both jurisdiction is held before the Supreme Court.
Thank you. Thank you.
Okay. What is the principle in the Karisa Chengo case?
Karisa Chengo was about the jurisdiction of the land, other courts of equal status by the High Court. That the land, I think the land court did not have jurisdiction because it was a criminal matter.
Put it more elegantly.
Jurisdiction of criminal matter is reserved for the High Court and not for the courts of equal status.
Thank you very much. I wish you well.
Thank you, Commissioner.
Thank you, Chair, and good afternoon. Mine is, you will be dealing with many matters when you come to the High Court because it's the court of original and original
jurisdiction
and limited criminal and civil jurisdiction. So on your first day, you will be dealing with criminal appeals in Kiambu here. And one of the things you will encounter it in murder cases, robbery with violence, sexual offenses, is the doctrine of reasoned possession. You're familiar with it?
Reasoned possession?
Yes, the doctrine of reasoned possession.
I would believe is goods found on an accused person, which were deemed to have been stolen from elsewhere, and
So,
handling stolen property.
So can you explain to us how somebody can be convicted for robbery with violence on the basis of the doctrine of reasoned possession?
I would have to answer the case in that one,
Okay.
Commissioner,
Okay.
because I've handled matters on handling stolen property.
Yes.
And the evidence is that if goods that were recently stolen from somewhere are found in your person, you can be charged with both handling stolen property and the act of robbery.
So why are you convicted of the act of robbery?
If from at the time, if for instance under 262 of the CPC, robbery is an offense where violence is used in the course of the commission of the offense. So if there was violence or there is evidence that maybe these people were armed with a dangerous weapon, or there was injury on the person or the victim who was robbed,
Okay.
you probably have to do that.
Okay.
And then the goods that were taken from the victim's house are then found in my person or the person of another person, accused person, recently.
Okay. So what the appellant is saying, and they usually say it in Swahili, sikuwa hapo, sikuumiza mtu yoyote, lakini ulinipata na mobile phone. So, but he was convicted of robbery with violence.
Yes, because he has to link himself from the offense of robbery. Yes.
So, in that case, does he bear the burden of proof?
In the absence of proof that he actually bought the mobile phone from elsewhere, he will probably be found guilty.
So what does the prosecution have to prove?
The prosecution have to prove that the goods that were found in him were stolen from someone and there was use of force.
Okay. Let's go to another issue. That is a very common issue when you become a High Court judge.
Very good question.
You encounter it. A petitioner comes before you. They have been waiting for their case to be heard for the last 6 years. He has been in custody 6 years waiting to be heard on a case of stealing. Okay?
Yes.
Stealing. He was not on bond. So he filed a petition says, I have not been granted a speedy untimely trial under Article 50. What are the factors you would take into account in granting relief, and what relief would you grant in this case?
I think if you were to find him guilty, you would have to count the time he stayed in custody as contributing to
No,
sentence
he's not. He's come to you. He has not been tried yet.
Yes.
But he's come Article 22 and 23.
Yes.
He's saying, Judge, my rights have been violated because I have not been granted a speedy trial. I've been waiting to be charged for this prosecution to prove stealing for the last 6 years.
Yes.
So you are the judge. You to hear it and grant relief. So what factors would you take into account, either in finding in his favor and granting relief?
That is right to fair. I don't know that this is part of fair administration of justice. His right to access to justice has been denied and interfered by the period he has waited. So I would allow him to go home.
You would allow him to go home?
Yes.
Would you grant him an acquittal?
Yes, I would discharge him.
Would you grant an acquittal with discharge?
I would acquit him.
Why?
Because
He has
I
not
think,
been tried?
yeah, well, the state has a duty to make sure that they do not punish people by keeping them in custody for long. So it is the state's responsibility as the office of the DPP to bring evidence in a timely manner and to make sure that justice is not denied. It's seen to be done and speedily at that.
Okay. You are the procurement tribunal for how long?
6 years.
Have you heard of something called the Singapore Issues? World Trade Organization?
Yes.
What are the Singapore issues?
Singapore issues. No.
Why is procurement such a big thing in world trade?
Because procurement allows government to. Government is the largest consumer of goods and services, and so public procurement comes to help government spend its money to allow economies to thrive. Because if government does not spend any money, then there is very little circulation of that money.
So what is the interest of the World Trade Organization in public procurement?
Is to facilitate trade.
Thank you very much, and wish you well.
Thank you.
Thank you, Chair. Good afternoon, Senior.
Thank you, Commissioner.
I was the figure when you are Chair, and you can confirm that all the things you have said at the introduction are true. And I really hope that you make it for this position. So, as a judge of the High Court, I have 2 questions. One is, as a High Court judge, can you make a declaration on the violation of right to life, even if an action or an action did not occasion actual death?
Yes.
In what circumstances?
In circumstances where someone has been subjected to indignity, servitude, to conditions that make the quality of life not worth living, abject levels of poverty. I recently,
That's okay.
yeah, sorry.
My second and last question is, are you aware of the Martha Karua versus Anne Waiguru's case?
Yes, I am.
From the High Court, the petition was dismissed on technicality.
Yes, I'm aware.
What did the Court of Appeal rule on appeal?
I think they remanded the case back for hearing, but by the time they did that, time had run out. Yes.
And the Supreme Court?
So the Supreme Court had no jurisdiction the time the case went back.
So you agree with the decision of the Supreme Court then?
Because election petitions, yes I do, is the Supreme Court.
What
Yeah.
does that tell you with regards to the provisions of the Constitution, Article 10, 159 on technicalities and others interpretation of the law 259?
I think the issue of jurisdiction is not a technicality. If a court or tribunal has no jurisdiction, they cannot hear the matter, irrespective of the fact that it's a technicality. So jurisdiction is over and above technicality. Technicality to be like maybe filing the wrong document before the court. Instead of a chamber summons, you file a notice of motion, or, you know. But I believe jurisdiction goes to the root of justice. He who doesn't have jurisdiction has nothing to give.
Okay. Thank you. And yeah, I think I'll leave it at that because there's also a new decision from the Supreme Court with regards to jurisdiction. But I said I only have 2 questions. Allow me to rest at that. Thank you so much, Chair. Wishing you the very best.
Thank you, Madam Chair. Just one or two issues. Madam, I'm also interested in this matter that when you are chair of this review board, in this case that we found earlier on between the Ministry of Education, the blockade entity, and we talked about public interests. How do you balance the two, the public interest and the law, taking into account that the public is very much interested in the decision to ensure that the public is not harmed? How did you balance? Because at the end of the day, on your judgment, you gave the right hand and you took it away.
Commissioner, when we, at the time that, I think in my introduction I said the future is digital. Actually, the present is digital. And that was a moment in time when we would have actually rolled out the digitization of the school processes in Kenya. But when evidence was brought before us by the parties, it looked like this was a scheme to defraud the public. Because based on the available evidence, all the tendering, the 3 parties who came before us had reached the final tendering stage. And the successful bidder, who was awarded the tender, had been awarded a certain price.
Okay,
And at the time, I'm just going to explain. At the time of the tender, his bid was the lowest. But at award of the tender, his bid shot up by 1.5 billion. And there was no explanation. So there was an element that there was something hand-to-hand that had happened. Because he gave a certain bid, but he was awarded a higher bid. So we looked at the issue of, do we allow the bid because the government wants to roll out a digitization process? Or do we save public funds because we could see clearly, even from the evidence, something was what I mean. There were capacity issues from the successful bidder at the time.
Okay.
Yes.
Except that your Director General had concurred and was agreeable. So I won't pursue that any further. But the effect of that judgment is being felt up to date, almost 10 years after. Now, I pray that you get this position, become a judge, that you be a state officer.
Thank you, Commissioner.
Under the Constitution, Article 232, again, there are some principles and values that are very dear to the Kenyans. There's also the principle under the Constitution, and I'm not a lawyer, on interpretation of the Constitution and the technicalities of procedures and all those issues. Among the 8 principles, can you share with us 2 that you would be that would be very important, valuable to you as a judge of the High Court?
The state officers are expected to be accountable to the public. And accountability is twofold. Accountability in service delivery, accountability in the use of the resources that are available to you as a public force. So you must ensure that in the event that you are responsible for procurement, for instance, you do proper procurement.
Second one?
That the resources that you allocated, you can be audited that they were used for the purposes for which they were given. So there is economy and proper use of the resources.
Thank you, sir.
Thank you very much, Professor.
Thank you, Council. I have two questions for you. Do you have a structured way of mentorship, like how you mentor younger colleagues behind you?
Commissioner, I take mentorship to be vertical and horizontal. So I mentor people within my sphere of influence, whether we are at the same level or they are below me. A case in point is the board that I sat in at FIDA. And it was my style to encourage everyone at the board to try something. And today, one of my vice chair is the chairman of the University Lecturers Association in WASU. Another one is the chair of the Ghana National Commission. Below me, I have mentored a lot of young people, both boys and girls. From my immediate family, I think I have 5 lawyers now, some at university, others at the School of Law, others in practice, that have come through my mentorship. I also mentor people to pursue other careers other than law. I speak at schools, I speak at events where I encourage people to choose their careers and decide what they want to do. So I do mentorship across board.
The structured way, how do you do it? Do you, like let's say your colleague board members, as you have said, or even people who are below you?
Yeah.
Is it through talks or do you call them one-on-one?
Most of my mentorship is individual because everybody has different needs. So if I identify, and even at FIDA among the staff, if I identified somebody who had leadership skills or some skills that they could be used elsewhere, I would actually approach them. One of the characteristics of myself is that I'm very forthright. So I'll just tell you as it is. Why don't you do this? Or this is not what you should be pursuing. Why don't you try it this way? So I do one-on-one mentorship.
So you call them?
Yes, I do.
So supposing you get this job and then eventually, of course, you retire, what kind of a judge do you want to be remembered for?
I would like to be remembered as a person who left the place that they found better than they found it. Commissioner, I believe in the Bible that tells us, the Christian Bible, Commissioner, that we should make the world or the earth that we inherit better for our kids and our grandchildren. So I believe that if I got into judicial, I would leave my footprints on the sands of time.
In which way?
I will, through judgments that I would write, make sure that I contribute to jurisprudence.
So good quality.
Yes, good quality judgment, well reasoned and researched, without fear or favor, and without bringing in my personal biases to my cases, just based on the facts and the law.
What about the timeliness? Some of the judges who are very highly rated, of course, they keep time. And
one of the things I learned was to write my judgments immediately that we finish the hearing. This is because at public procurement, we only had 21 days. By the time you go to hear the case, it was on the 14th day. So you'd be hearing a case with 7 days to go. And the case may take 2 or 3 days. So you find you have 2 or 3 days. So I will make sure that they're delivered with the speed that they deserve.
thank you, Councillor.
Thank you, Commissioner.
Thank you very much.
Thank you, CJ. Once again, good afternoon.
Good afternoon, Commissioner.
I remember when you were working for FIDA, we had some engagements when you were working on the sexual offences, within the Sexual Offences Act.
Yes, we sat together.
Yes, I remember that. Now, I want to just continue that conversation on performance. There's a general feeling, especially amongst the members of the bench, there's that argument that this business of measuring the performance of a judge, especially when it comes to statistics, tends to water down the quality of work a judge does. The feeling being that a judge should not concern himself with how many decisions he's able to churn out in a given time, but mostly concerned himself with research and making sure that the judgments are well reasoned and based in law. What is your view about that?
My view is that justice delayed is justice denied. And so if a judge concludes a case today and gives a decision in 2 years, it may not help the parties. It may not even help to alleviate the situation if there was a public interest issue. So timely decisions are key to actual dispensation of justice. What I learned at the Kenya Anti-Corruption Commission was that what gets measured gets done. And therefore performance measurement is a good tool to any institution. And I know with the performance measurement, especially the ones that we did at the Kenya Anti-Corruption Commission, you set the targets yourself. At FIDA, we used to have a biannual measurement tool we used to call the RBM. And at RBM will ask you, you told us that you will file 5 public interests, public interest matters. And now you have filed 1. What are your challenges? Because at that time we are able to help the legal counsel or the department that is struggling. Or you told us that you will ban this budget within this year. Why do we still have and spend budget in your programs? So if you are able to measure in a timely manner, then you are able to get it done. But if you don't measure, if there is no pressure, I'll write it at my own leisure and pleasure.
But do you think that pressure sort of waters down the quality of work that a judge does?
I don't
Especially
think
when
it
it
should.
comes to the kind of decisions they challenge.
I do not think so. Because look at what is happening at the elections court. We now have a 6-month cycle to give judgments in the elections court. And so when the matter is filed, all parties know that they have a 6-month timeline. There's a shelf life to that case, which is 6 months. So if there are structures in every court, let's say for instance in the commercial court, that you cannot keep a matter beyond 1 year. All parties are on hand, practice directions exist, and there is a conversation between the parties that bring the case. If you're bringing the case to put it in our shelves, keep it in your office. If you're bringing the case to argue it, please let's argue it. So I think if people know that they have to do it, they'll do timely research, they'll do timely case analysis, they'll hear the matters, and they'll write judgments. So it's just a question of having targets and knowing that those targets are what you get measured by. What Commissioner, I noticed at the courts in the US was members of the bar and bench have got what we call the Hall of Fame. What are you remembered for as a judge? And I've attended a few functions where people are remembered for the sound judgments that they gave, for the service that they gave as judges, or as lawyers, or as even general counsel in public institutions. And that gives the others who are behind or who are serving there impetus to know that my good work may be recognized. Maybe we can have some hall in the Supreme Court where we put all the people with sound, well-reasoned judgments that have come to...
Or the highest number of judgments too.
But well-reasoned.
Okay.
Yes.
Thank you very much. I don't have many more questions to ask you. I've looked at your application. The documents are in order.
Thank you.
The report we have on your background is that you're strict and unbiased. You, on issues especially related to gender, you are good in cyber security laws, and you are a good administrator and manager, especially during it was exhibited during your stint at FIDA. You come highly recommended, and I wish you well.
Thank you, Commissioner.
Thank you very much, Nancy, for that very engaging interaction this afternoon on the behalf of the Commission. We wish you well. I think this brings us to the end of the interview, but before you leave, you have an opportunity to ask us a question.
I want to first of all take this opportunity to thank you for, first of all, shortlisting me. This is the second time I've applied and got into the shortlist, and giving my opportunity to at least articulate my credentials before you. I thank you for that honor. It's an honor and a privilege to get this far, even as a lawyer. Really, I am honored and humbled, and I'll wait your verdict.
Thank you very much. We'll get in touch with you when we complete the process.
Thank you.
But we wish you well and encourage you to continue doing the good things.
Thank you, Chair and Honorable Commissioners. Thank you. Thank you for your time.